The opinions expressed on this program represent the viewpoints of individual authors or contributors and do not necessarily reflect those of Troy University.
Welcome to EconVersations. I'm your host, Dr. Dan Sutter of the Johnson Center for Political Economy at Troy University. America is a constitutional republic, and our national constitution, drafted in Philadelphia in 1787 and then ratified by the states, is well recognized and revered. The presidential oath of office and the induction oath for our military both mention a duty to defend our Constitution. Well, states have constitutions as well, although they are not as prominent in our public discourse as our national constitution. And Alabama's constitution and constitutional history are distinctive in several ways. Joining me on EconVersations today to discuss Alabama's state constitution and our constitutional history is Dr. Alan Mendenhall from Faulkner University's Jones School of Law. Dr. Mendenhall has a law degree from West Virginia University, a PhD in English from Auburn University. He's the director of the Blackstone Burke Center for Law and Liberty at Faulkner, and he's also the president of the Montgomery chapter of the Federalist Society. Well, welcome back to the show, Alan.
Thank you, Dan. Thanks for having me again.
So I want to just first touch on the point that states have constitutions, and people might not be as familiar with state constitutions as they would be the constitution that many of us have learned about. That's our federal constitution. So what exactly is the role of our state constitutions?
Well, it's a great question. And America has a system of federalism that was unique compared to the British tradition from which it came. So we've always struggled to implement the common law system in the United States of America because the common law is sort of a homegrown, bottom-up institution. But how does it work in a system of federalism when you have these different states with different constitutions and different laws kind of coming up from the bottom? And each state, as you say, has its own constitution. They're all a little bit different, but they primarily have the same components. So you're going to see separation of powers in all of them, an executive and a legislative and a judicial branch is common to all of them. So they all somewhat resemble the United States Constitution, but in fact a lot of them protect even greater freedoms and liberties than the United States Constitution did, at least prior to the Bill of Rights.
Well, that's a good point, because that's what we want to get into. At one level, all the states seem to have the same sort of structure with the executive, judicial, and legislative branches, but I guess there are some important differences, and they can be important in terms of, sometimes you'll see a case where one state has a law that gets struck down as unconstitutional, but it's a very similar law in another state that gets upheld, right?
That's right. Yes, that does happen. It happens fairly regularly, which is why you have federal circuit splits sometimes, and in the Supreme Court doesn't always have to resolve a split. There's been a tradition in past decades of the Supreme Court kind of intervening and resolving circuit splits, but my prediction is that under Chief Justice John Roberts, we'll see a little more variety in the system, that he may not break up those circuit splits, as in he and the court that he oversees won't take cases just to resolve circuit splits.
And another thing that's different between many of the states and the federal government is that we've had one federal constitution since 1787. I guess technically you could say that our nation's had two constitutions, the Articles of Confederation before that. But we've had really pretty much from the time we had the president, 1787 on, we've had one constitution at the federal level, but states have replaced their constitutions, right?
Yes, that's right. And in fact, Alabama is the perfect example of that. We've had 6 constitutions. This is the current Constitution right here, and I've got it in 2 volumes, and this volume doesn't even have all of the amendments in it. So by my count, we're up to 946 amendments, which makes our Constitution 12 times longer than any other state constitution. It makes it 44 times longer than the U.S. Constitution. India's Constitution is considered the longest constitution in the world, and ours is only it is only a third of the length of ours. So that's how long our Constitution is. A lot of people say the Alabama Constitution is the longest constitution in the world. I don't know whether that's a fact, but I haven't seen anyone demonstrate that there's a longer Constitution. 90% of this Constitution consists of amendments, and so it is truly a long and unique Constitution. Now, the constitutions you're pointing to here, we got 1819. That's when Alabama first became a state. That's when we had statehood. The capital was up in Huntsville temporarily. Then it was moved to Cahaba. Didn't go to Montgomery until 1846. But then we have the 1861, which was the secession Constitution. As you can see, we have 1865 and 1868. Those are the two Reconstruction Constitutions. Then we have the 1875 Constitution, which tried to undo some of the things that were put into place under the Reconstruction Constitution. And then, of course, we're at today's Constitution, which is the Constitution of 1901. Now, those Reconstruction Constitutions, in particular, between 1865 and 1868, you had elements that disenfranchised a lot of white voters in order to, I mean, you had the Republican Party in power. This was the party of Abraham Lincoln. And under Reconstruction, the idea was to basically re-educate and to put under military control these former Confederate states. And so that's what was going on in those Reconstruction amendments, constitutions. And by the time you get to the 1875 Constitution, you've got new people in power, or you've got the Reconstruction's done, and you've got what becomes known as the Bourbon Democrats taking control. This is not bourbon like the drink. This is bourbon as in like the French Bourbons who wanted to restore political society from prior to the French Revolution. It's a similar idea. They wanted to restore society to the pre-Civil War state that it was in. So these Bourbon Democrats try to, well, first, they try to disenfranchise black voters, but under the 1875 Constitution, they realized that there's still so much federal oversight that there are things they're not going to accomplish. They don't actually get to fully realize some of these efforts at disenfranchisement until the Constitutional Convention is called in 1901 for the 1901 Constitution, and that's when you sort of see these efforts at disenfranchisement realized. Some of them.
Now, I believe you've mentioned to me that your center at Faulkner is going to have a symposium this fall to sort of discuss or celebrate Alabama's 6 constitutions.
Well, it's not a celebration or a commemoration. It's just a symposium on Alabama's constitutions. We're going to have historians, political theorists, judges participate, and it will be part of the bicentennial. And we're going to look at the constitutions and consider different elements of it. Bill Stewart from the University of Alabama is a well-known historian, an expert on the Alabama Constitution, has authored a couple of textbooks on the Alabama Constitution, which has been amended so frequently and so much that those textbooks are already kind of dated. Yeah. So somebody needs to step in and fill Bill Stewart's shoes and kind of update those textbooks. But yeah, that will be October 30th, which I believe is a Wednesday. It will take place in the State Archives building, downtown Montgomery. And it will be a day-long event. And as I say, we'll have different panels throughout the day. Lawyers will be able to get CLE credits, but it's open for the public. It's open for anybody. I would encourage teachers to take students. I know it'll be during the school hours, but perhaps you could arrange a field trip. And I think there will be some kind of education credits that teachers can get as well for attending.
So you mentioned the amendments, and I want to touch on that because that's another way in which the Alabama's state constitution differs from the federal constitution. Our federal constitution has been amended, I think, 27 times in 230 years. Alabama's constitution, I guess, I know we're over 900.
Definitely
amendments.
Over 900. Yep.
And so there's a very, over a period of just like 120 years. So we have a very different rate of amendments. How can we explain why it is that it was our federal constitution amended so few times, but the Alabama Constitution so frequently amended?
Well, part of it, I think, is just it's more difficult to to amend the U.S. Constitution. I mean, one way of amending the U.S. Constitution is through an Article 5 Convention of the States, and that's provided for, obviously, in Article 5 of the Constitution, but it's never happened. We've never had a constitutional amendment that way. The other way is to get the 2/3 majority of the House and Senate to support the amendment, but then you've got to send it to the states for ratification, so then you have to get the states to ratify it. It's a difficult process, and it's made to be a difficult process. It's meant to be, the Constitution is meant to be something that's difficult to amend. The Alabama Constitution is a little easier to amend. You can either call for the House and Senate can either call for the Constitutional Convention by majority vote, or you could get the majority of both the House and the Senate to pass an amendment and put it on a ballot for people to vote on, and that's the way we see it all the time. It seems as though every time we're going to the polls, we see a new amendment that we're going to be voting on. But another reason for this is the issue of home rule. So we only have, like, in that 1901 amendment, there are really only 7 counties that were provided limited home rule, not even full home rule. It was like Jefferson, Lee, Mobile, Madison, Montgomery, Shelby, and Tuscaloosa. But what that did is there was a concentration of power in Montgomery, in the state legislature. And this is part of the Bourbon Democratic plan, was that we're going to make it difficult for all these different counties and municipalities and localities to, for example, raise taxes or do different things because we want control. We want all these things having to go through the state legislature. That was the way that the Bourbon Democrats wanted to take control over the entire state. So as a result, if you have, you have different counties wanting to do different things, to raise money or do whatever, and they have to go through the Alabama legislature in order to pass these local laws. So that's why we have so many local laws in the Alabama Constitution, in our amendments. And another unique thing that's related to that is our basically what would be a tax code in other states is written into the Alabama Constitution. So that's highly unusual, but it creates centralized control over the taxation process right there in Montgomery legislature, so that it can't be outsourced to county commissions or our local jurisdictions.
Let's get into this idea of home rule a little bit, because one thing that people might not be aware of is, like, cities or municipalities have a legal structure to them, and that legal structure really sort of flows out of a state constitution in most cases. So, what you're talking about is that Alabama has different rules, really, sort of for establishing cities or what cities can do under our Constitution relative to other states, right?
Yeah, that's correct. And same with counties and county commissions. And most people don't realize this, but municipalities are created as corporations. They're corporations with sort of the character of the state, and they're given sort of powers of government, delegated those powers, let's say, by the state. So they are different entities from counties, but you're correct in that in Alabama, these entities have limited control. They're not sort of sovereign, and I hesitate to use that term because they're not sovereign really in any state. They're all part of the state, but in most places, counties can control their local governments with much more ease and with much more let's say latitude than they can in Alabama. They don't enjoy as much power as they do.
And this also relates back to the whole issue of federalism that we talk about between the federal government and the states. But we also have a system of 3 levels, at least 3 levels of government, with cities being another element. And from an economic standpoint, we often talk about the competition between jurisdictions or the ability of cities to act a little bit, almost entrepreneurially and have local powers to take care of local issues. and it also impose local taxes, so that and that allows a lot of diversity across cities.
It does.
But cities have to have a lot of authority, have to have more authority to be able to sort of do that, right?
That's correct. Yeah, that's the authority that they generally lack under the current 1901 Constitution. There have been a lot of efforts to reform the Constitution. Alabama Citizens for Constitutional Reform, among other groups, have tried for years to either call for a constitutional convention or to revise the Constitution in different ways. And it's still a conversation that's ongoing. The United States of America has the sort of the longest ongoing operative constitution in the world, and as far as duration. People look at that and they look at constitutions that generally are of longer duration, and they say, well, these constitutions typically enshrine general principles of law. They provide a basic framework for government within which there's some play and within which there's some ambiguity that gets resolved through the court systems or through different statutory laws that are enacted over time. So it'll be interesting to see what the longevity of the Alabama Constitution is. Again, I'm referring to duration and not length. We know that it's a beast of a document, and we'll just have to see whether it continues to grow or whether the state will eventually call a constitutional convention or something to that effect and end up revising the Constitution.
Now, one thing you mentioned the fact that the federal Constitution has been amended so few times, but there could be one approach to thinking of the role of constitutions under which we could say, like, well, maybe the federal Constitution hasn't been amended enough. That maybe if we took like an idea known as enumerated powers more seriously, the problem is, well, the federal Constitution hasn't been amended enough. Let's get into this idea of
yeah. So there's an argument that you could say that there are certain things that let's just hypothetically say it's Congress. That's the branch of government we'll choose. That the Congress isn't authorized to do X, and for it to do X, it really there ought to be a constitutional amendment that enumerates the powers, that names the powers. You see this, I think, as a growing problem in the administrative state, which I take to be almost a fourth branch of government. That so you've got your executive, your legislative, and your judicial branch. Well, then you have these state agencies that exist over here, and they're creatures of legislation. So they're created by Congress, but they operate under the executive branch, but they have their own court systems. They have their own head of the agency that operates as an executive, and then they promulgate all these rules and regulations. And so they even have a legislative function. So they're like miniature governments, and they continue to grow, and they don't have a lot of accountability because Congress actually kind of likes to have these things going out of control. Like even if let's say you're a conservative that wants to complain against overregulation, well, now you have something to point to. You've got the EPA or whatever it is, and you can attack them, but without any accountability whatsoever. And so it gives you something to blame. But meanwhile, these things have grown, and there are a lot of questions about whether the rules and regs they're passing have the force of law, whether they're constitutional. And these are new issues that we're going to be dealing with. I suspect we're going to be seeing a lot of Supreme Court opinions on this in the near future, given people like Neil Gorsuch, who is on the Supreme Court now, who feels pretty passionately about reining in the administrative state. So we'll be presented with new issues regarding those.
Well, just in terms of amending the federal Constitution, and I remember during the debate over the Affordable Care Act, somebody asked Nancy Pelosi and say, like, where's the constitutional authorization for us to do something like this? That view, if you have that view that the Constitution says what powers the government has, and if it's not in there, then that view of a constitution would say, well, you've got to first amend the Constitution to make sure that the people will authorize that you can legislate in this area, and then you can legislate.
Well, that's exactly right, and there are people that have had that similar argument with the U.S. Supreme Court and federal courts, and they've argued that the courts have been exercising legislative functions rather than judicial functions, that they have been interpreting laws in such a way that what they are in fact doing is making laws rather than interpreting laws that are written on the books, whether they're correcting the laws or they're reading them in a certain way to either validate or even abrogate them in ways that have real-world effects on what the state of the law is. And it could be in a state jurisdiction like Alabama, let's say, or it could be federal law that they're dealing with and the administration of that on a local level. But at any rate, there's that conversation as well.
Yeah, we mentioned some of the elements, because I think another distinctive element of Alabama's Constitution is that we have very strict tax limitations that are built into the Constitution.
That's right.
Our top income tax rate is set in the Constitution. Our top property tax rate, and I think also the base for the property tax, is set in the Constitution. And that's very distinctive, isn't it?
It is very distinctive. Yeah, it's very distinctive. I don't know, and first of all, I'm no expert in state constitutions. I'll say that, but I don't know of other states that have something quite like that. As I mentioned earlier, home rule is not as strong of an issue, is not as big of an issue in other states, and certainly not aware of any state that has what essentially would be the tax code written into the Constitution. I mean, a Constitution typically addresses more general principles and provides the blueprint for government, but doesn't micromanage the way ours does.
And that's certainly shaped politics, because over the last several years. Like for instance, in 2019, the governor called a special session to try to raise the gas tax, but
right.
We didn't try to raise the income tax. Although over the last several years, which the general fund of our state budget has been under so much pressure, and neither of our governors at any points have actually gone ahead and suggested, oh, let's have a constitutional amendment to raise that top income tax rate so that we could raise the income tax. They've pursued other means of trying to raise revenue.
Yeah, I mean, amending the Constitution or calling a constitutional convention would be a controversial thing. I mean, I think anytime you're talking about something so major as that, it's going to be controversial. So most political leaders don't want to wade into that kind of controversy, first of all. And then there are a lot of people that like the way the tax structure is set up, a lot of businesses that feel that they're advantaged by it. And so there are political pressures there, I'm sure, preventing people from taking up these kinds of matters at that level.
Well, our current Constitution in Alabama stems from 1901, and we would really be remiss if we didn't mention the fact that this Constitution was adopted in 1901 really for very much racist purposes, right?
Yeah, I don't think you can't talk about the Constitution of 1901 without discussing that element of it. John B. Knox, who was the president of the Constitutional Convention, basically said that the purpose of meeting for this Constitutional Convention is to institute a system of white supremacy, and there's just no way around the fact that that's motivating a lot of the Constitution. So how was that accomplished? Where does that evident? Well, Section 181, you had literacy tests for voting. There were property qualifications that you had to have for voting. There were Section 194 had a poll tax, and that prevented people from turning out to the polls. Section 102 prohibited interracial marriage. Section 256 had called for segregated schools, so you had segregated school systems. So all these issues, and these all were either overturned or abrogated or nullified or negated or whatever verb you want to use through federal law over time. So the literacy test and poll tax, that was all done with the Voting Rights Act. Loving v. Virginia, after Loving v. Virginia, the ban on interracial marriage is unconstitutional. Brown v. Board of Education ended segregation in public schools. Even the system where I talked about earlier, where every county had just one senator and one representative, so that there was disproportionate power given to rural communities, so that even that was done away with through cases in the 1960s, cases like Baker v. Carr and others. And so some of the racist elements of the Constitution have basically been rendered inoperative. But the language is still there. The language is still problematic. It's still embarrassing that it's there.
Yeah, so I mean, in one sense, as you mentioned, like the racist elements of the Constitution are no longer in effect, but I guess they are still printed in the books there, although they are inoperative at this point.
Right. Yeah, and there have been movements and calls to go through and delete or revise the racist language in there to varying degrees of success and to varying levels of reception among people that would have the power to do such a thing. I think some people are concerned that changing something that's inoperative will really doesn't do anything because it has no practical change. But a lot of people think it's embarrassing for the state to have that kind of language in there still, and that it ought to be changed.
Well, and also, I mean, if the idea of a constitution is sort of like rules that bind us all together, I mean, it's very clear, even if they're not effective now, that this was not a constitution that was meant to bind us all together.
Yeah. So I think that's exactly right. And I think a lot of people, I think most people of good faith reasonably agree that that language ought not to be in there, but there would have to be a process to remove it, and agreeing on a process is a much more difficult thing for people to do. And then if there's a process, someone has to control the process, someone has to be involved, and there's a level of trust that gets brought up. Like, who controls that process? Is it someone that people can trust? I mean, we're talking about tinkering with language in the Constitution, so is anyone going to pull a fast one or try to slip something in there that might have an operative effect? And so you get into those kinds of issues as well.
Right.
It's a really difficult problem. There aren't easy solutions to it.
And clearly, a convention that went beyond the scope of what it was supposed to do is not without precedent, because the Philadelphia Convention was supposed to amend the Articles of Confederation to decide to do something else, right?
That is exactly right.
And I mean, it also sort of shows that the difficulties of trying to come up with a new constitution or alter it in a large fashion like that is part of it. The reason it's there is that these are rules, these are fundamental rules that help sort of form our expectations in society. They form really the backbone. And so when you start to think about changing those rules, you're changing a lot of a lot of expectations, a lot of plans are built around those rules, and that's just part of what's going to make it so difficult to try to adopt a new constitution, right?
That's correct, yeah. And if you look at the different articles, so the Constitution is separated into articles. If you look at the just the first few, you'll see that the basic framework of government is provided for in those. You'll see, in particular, in the first article, declarations of where the powers of the state reside, which is they reside with the people themselves, which is why the people should be the ones that, if they're going to be calling for a constitutional convention, ought to be calling it. But there's a little bit of tension with that type of language and some of the language that we have that gives the legislature such power in the state. And in fact, the amendment process itself originates chiefly in the legislature here, and not necessarily the people. There's not a citizens referendum that gets called. That process begins through political pressure. Yeah, the people can put political pressure on the legislature, but that process really originates with them.
Well, thanks for coming on and talking about these issues. They're very fascinating,
Yeah, thanks,
and something I think all Alabamians need to be aware of the important role of our state constitution. And so thanks for coming on, and thanks for joining us. Join us again next time for another EconVersations.